anything. He's a peace-loving Kenyan. He has called upon all his supporters to take whatever outcome of today's judgment, knowing that we shall proceed to the Court of Appeal and maintain peace and order so that we can give our institutions sufficient time to interrogate this judgment today.
How best, perhaps using very few words, would you describe the judgment? Using very few words.
Gravely disappointing. Gravely disappointing.
Thank you very much. Thank you. Any other counsel wants to speak to us, please? All right, that there is Kirinyaga woman representative Njeri Maina, who was a petitioner in this particular matter, the consolidated petitions on the impeachment of former Deputy President Rigathi Gachagua. Nitazungumza na mawakili kidogo tu alafu nitakuita. So, yes, the court has ruled that the court has upheld the impeachment of Geoffrey Rigathi Gachagua as second Deputy President of the Republic of Kenya, though the rider here, the court admits that the rights of Geoffrey Rigathi Gachagua were infringed, especially when the Senate proceeded to hear the matter without him when he particularly fell ill and was taken to hospital. But upon this recognition, the court says it has offered a remedy, and that remedy is 50 million shillings to be paid as damages payable by the Senate of the Republic of Kenya. But we have listened here to Njeri Maina, who is a petitioner and also a lawyer, stating that no, we will not be accepting these monies that have been offered. I'll bring it to you, Dan, but later, even as more counsel come out of the courtroom, we'll be getting to hear from them on what exactly the next course of action will be. Today we did not see Geoffrey Rigathi Gachagua here in court. He has been at home. We saw him earlier joined by other opposition leaders, Kalonzo Musyoka, Eugene Wamalwa, and of course his family, Pastor Dorcas and his two sons were there, Kevin and Keith. And of course, we expect that he will be giving an address, a reaction to the ruling that came from the courts earlier today. Perhaps he'll give this reaction tomorrow, who knows, after consultation with his legal representation. We have had Senior Counsel Paul Muitek asking that they be furnished with all the documents, all the recorded videos of this particular proceeding and the reasoned judgment of this proceeding, so that they may now take the next course of action. Njeri Maina is here on record saying that she has already filed a notice of appeal, meaning they are soldiering on, headed to the Court of Appeal and try and have this decision by the three-judge bench here at the High Court quashed. So, Dan, we still wait here right outside the Milimani Law Courts. Once the lawyers are come out, they should be actually here in the next few minutes. But remember, it is a journey that started from October of 2024 when that impeachment process started, when the Member of Parliament for Kibwezi West, Mwangi Mutuse, filed or at least tabled that impeachment motion at the National Assembly. It was quickly hastened, taken to the Senate, and we saw a lot of things happening too fast at that particular time. And we are seeing more counsel coming here. I'll speak right now to Counsel Ndegwa Njiro to tell us, he has said in court that they will not sit and watch the Constitution violated. Counsel, you're live on NTV.
I didn't say we shall not sit and watch the Constitution being violated. I said we shall not watch the court presiding over the funeral of our Constitution. Yes. We said we shall not watch the court preside over the funeral of our Constitution. We have sat for 10 hours in a funeral for our Constitution, yes. A funeral for our democracy, a funeral for our institutions. We have presided over the funeral of the country and the Republic of Kenya.
Why would you particularly say this was a funeral of our Constitution?
Because you could see the judicial nonsense that was there. They allow some of the things. They say His Excellency Gachagua's rights were violated. Yeah. And instead of doing what is rightfully constitutional right to quash, they avoid. When they say that there was no modification of the procedures in the Senate, they recommend for legislation. That's what I've told them. We never came here for recommendations on legislations. We have elected members of parliament to legislate. So we never came here for to seek orders and to seek recommendation for legislation. That is why we are saying the Constitution has been buried today.
The Constitution has
Yes. Yes.
Your client has actually, because you represent
Yes.
other members here, the court said you cannot have two deputy presidents.
No, that's
at the same
nonsense.
time. You cannot.
That's again judicial nonsense. It's judicial nonsense because the consequences of finding that the impeachment has been quashed is that Kindiki should have vacated. I don't know where they got that from. That's why you're calling it judicial nonsense.
But you are not pursuing that in the court. You said you're
We are going to the
seeking
Court of Appeal.
to go back to office.
We are going to the Court of Appeal. You have heard how the court has grossed over the other petitions and just dealt with one petition for His Excellency Rigathi and ended up with judicial nonsense and judicial absurdity. We cannot agree to that.
Senator Mans, Harrison.
Yes. Look, we had a bit. You want to finish?
Yeah, no.
Let me finish.
No. Go on.
You see,
Please.
just finish.
Come in.
When a breach has been found and cleared that the proceedings had a problem, when a right has been breached and when you have not been given a right to be heard, that's a very cardinal issue. Therefore, my position is that, it should have been annulled. It should have been annulled. And that's the conclusion automatically. Because you have not been accorded an opportunity to be heard. And therefore, it can only be annulled. You can only say that, the court did not arrive at the right decision. We should have automatically had Rigathi Gachagua reinstated.
Okay. There's 50 million shillings on the table for the client that all of you probably represent. Are you going to take it? Are you going to advise your client to take them?
Well, we have to go to the Court of Appeal and discuss all the pending matters, all the issues. The right to be heard is very important. And therefore, the breach is definitely greater than what it is and what has been awarded.
Perhaps very briefly, Harrison, you wanted this judgment arrested. Very briefly, why?
Yes. What a contradiction! You have heard these judges say, "Oh, Honorable Gachagua's your right was impinged. It was infringed by the Senate. I'm fining 50 million upon the Senate because of infringing your right to be heard." Excuse me? We filed a petition and asked them, A, make a finding that Article 145(1) and 2 of the Constitution was breached. What does it say? It says that all the members of the National Assembly must be present. All. Now, this judiciary, they found out, oh, mamma mia, the whole impeachment process will collapse because the Banisa people did not have a member of the National Assembly. The Gwasi people, Suba South, today, they didn't have a member of the National Assembly. You know why? And he pointed out that someone elected to go to the executive and left their constituents totally without representation. I'm talking about Mbadi.
Mbadi was a nominated member of parliament, just to correct you. Yes. And you didn't have a member of National Assembly for Magarini. You also didn't have a member of National Assembly for Banisa I mentioned. All right. Now, these people did not vote. The Constitution demands, and I challenge you, what Constitution were they reading? I challenge you. If you have a Constitution, have a look at Article 145, Subarticle 1. It is all the members of the National Assembly, all. So they suppressed the hearing of my petition, and they have no shame saying that Honorable Gachagua's right to be heard was suppressed. The Court of Appeal certified the application that we filed as urgent. Now, the Court of Appeal has to constitute a bench. It doesn't take 2 minutes or 3 minutes. They know, but they acted blind to it. And the question is now, what have they done in excluding one of the petitions that bore the weight of these very same issues? All right, Harrison, you've made your point. Well, of course, we'll be following at the Court of Appeal. Allow us to speak to counsel for the respondents as well, so that you tell us. All right.
Kenyan people ought to know. Kenyan people ought to know that the motion, no, hold on. Let me finish because you never gave me another. The motion that was tabled by Honorable Mutuse was dead on arrival. This is what the judiciary saw. This is what these judges saw. What do we mean? Standing order number 64, substanding order number 5 says that if you withdraw the signature, any member of the National Assembly withdraw the signature, that motion dies at that point. There was nothing to take to the Senate. There was nothing to resolve upon. There was nothing to impeach Gachagua. Let's be real. Let's be serious in this country. That standing order says there was no motion to debate. Honorable Mutuse knows that. He did not address that in my case. None of the people addressed that in my case. So the question is now, did the Speaker of the National Assembly know? Yes. Did these judges know? Yes. Why is it they have avoided consistently this particular petition? It is because they know. Sorry, my phone. Sorry, David. They know.
Point made, Harrison Kinyanji. Wakili Harrison. Let's now hear from Senator Wakili Tom Ojenda, counsel for the respondents. We respectfully, we have heard from 3 counsels. Professor Ojenda, how do you react to this particular ruling?
No, the ruling delivered by the 3-judge bench, Judge Ogola, Mugambi, and Mrima, is a sound ruling, a sound decision. It has upheld the impeachment of Rigathi Gachagua.
Was he impeached?
It has also confirmed that the appointment of Professor Kindiki as Deputy President was done in accordance with the law. There was no need to have the input of IBC. And the ruling is quite substantive. It has dealt with the issue.
Was there any voting? Was there any voting in the National Assembly?
Your matter has not been wait.
Was there any voting? There was no voting.
Harrison, allow us to speak to him. Then we'll speak to you. All right.
The court has held that the National Assembly process of confirmation was a process that had no constitutional foundation, and therefore the court has found that the National Assembly, though it confirmed Kindiki as the Deputy President, needed not to go through the process. But number 3, and this is important, under Article 157 of the Constitution, an impeachment is final. It is a final process. And that is why, though the court found that Senate ought to have accorded Rigathi Gachagua an adjournment, it has not faulted the impeachment. The impeachment is final. It has only awarded damages of 50 million to be paid to Rigathi Gachagua for not having been heard on an adjournment because Senate rejected the adjournment. That is the only positive finding. But I'll tell you this, that since the petitioners will file an appeal, there will be many appeals, Senate and other parties will file a cross appeal because you can only file one appeal. Once an appeal is filed, then you file a cross appeal. So, I think the court has gone through the issues decisively. It has dealt with constitutional issues, the thresholds. It has found that the National Assembly went through the process of public participation properly, and there was sufficient public participation. The National Assembly presented a formal motion, went through public participation, presented a proper case before Senate, and Senate voted properly for the decision that eventually led to the impeachment. I think this is a good decision.
You're calling it a good decision, yet, you're calling it a good decision, yet the court has, and this seems to be the main pain points for the petitioners, the court has acknowledged an infringement of a right. And it has gone ahead, yes, to offer a reprieve in terms of 50 million shillings, but many would say an infringement of a right should not have a reprieve.
The court has made a finding on the exercise of discretion by Senate. It has found that the Senate ought to have allowed Rigathi Gachagua more time to present his case. Remember, the National Assembly had presented its case and the witnesses had been cross-examined by Senate. So the court has simply said you should have allowed Rigathi Gachagua equality of arms. It does not take away the vote. It does not take away the 11 grounds, out of which 6 failed but 5 succeeded. Remember, in Senate, 1 ground is sufficient to impeach any person during an impeachment procedure. And that is why the long analysis on impeachment, the provisions of the Constitution, Article 180, and how governors are impeached the court was able to go through all that and analyze. This is a balancing act. In the end, the court balanced by paying for the injustice that it felt had been carried out by the improper exercise of discretion by Senate. But does not in any way mean that Senate acted illegally. It merely acted at the time because it did not have material before it, the material that showed where Rigathi Gachagua was at the time. But it has said, because of that, the possibility that you should have adjourned, we will give damages. But that does not affect the impeachment. Rigathi Gachagua stands impeached. That's the position.
A quick one, Wakili. Are you saying that the process that you took Gachagua through was free and fair, yet the court actually said that he was infringed?
The process that was followed by the National Assembly, public participation, was found to have been proper. That's number one. Number two, Senate needed not to undertake public participation. Number three, the court only faulted Senate for not having allowed the adjournment to the next Monday or Tuesday because there was some time. But has said that because Senate exercises discretion through a vote of senators, that decision or that final decision or outcome cannot be faulted.
What are your chances at the Court of Appeal because they filed an appeal already?
We win our cases. I can assure you that the political question doctrine will be dealt with at that point. Right. The independence of Senate will be dealt with at that point. And I'm sure that the Court of Appeal will not arrive at a different decision on the finality of the impeachment and Article 157 of the Constitution. Thank you.
Thank you. Okay. Senator Professor Tom Ojenda there, the Senator for Kisumu, and also a counsel for the respondents in this consolidated petition in which, amongst other people, former Deputy President Rigathi Gachagua was challenging his impeachment in 2024. The High Court has since ruled and upheld that particular impeachment, but they have found that the Senate in particular infringed the rights of Rigathi Gachagua by not giving him a fair trial and thus awarded him 50 million shillings. Gachagua's counsel, the Gachagua's lawyers are saying, we do not want this money. We did not come to court for the money. We are proceeding to the Court of Appeal. Dan, they already have are stating, especially Njeri Maina, the Kirinyaga woman representative, also a petitioner in this particular case. She states that she has already filed a notice of appeal and she'll only be formalizing it to now have the actual appeal filed. So let's see when they go to court and what Rigathi Gachagua will be saying following this particular ruling. Dan.
Thank you very much, Ibrahim Karanja, for that and just for following up right from the moment that the case